I'm Paul Marcus from the College of William & Mary Law Faculty, and I'm joined today by my colleague Adam Gershowitz, and we're going to be talking today about an issue that ought to concern all of you, and that is, when can police officers search your cell phones? Fortunately, Professor Gershowitz is a true expert in this area. He's written about it, he's spoken about it, and I can say without hesitation he's influenced our United States Supreme Court on this issue. The court decided a major case involving police search of cell phones just a few months ago. And what we're going to be talking about today is the impact of that and the unanswered questions from that decision. Now, Adam, let me turn to you at the outset and ask you, when we're talking about cell phone searches, what kind of situations do we have in mind?
Well, the law that governs this area has been around for a long time, and when that law was established, we were really talking about cases in which police would stop people on the street and they'd take a search of items that were on your person, things like what might be found in a package that's on you, a cigarette pack, a wallet, things that were closed, tangible, physical containers on a person. And that's where the law for all of this originated, about whether the police could search without a warrant as part of an arrest.
Now, prior to the court's decision in June, I believe, what was the prevailing law, if there was one, throughout the country?
Yeah, the law was really broad. There was a fairly broad exception which said that when police conduct a lawful arrest of a person, they could search as part of that person pretty much anything that was on the person. In fact, anything you could conceivably think of that would be on the person, and they would allow that to be done to protect the officer, to make sure there was no weapons stashed anywhere, and also to prevent any evidence from being destroyed. But that law, that exception to the Fourth Amendment's warrant requirement, was designed in an era where the things that would be searched were tangible and limited, not like the sort of things that we see today.
Yes, but I take it the government argued before the Supreme Court that even though it was a different kind of item they were searching for, nevertheless, a warrant would really be inappropriate.
Yeah, what the government argued is what we hear a lot about in law school and in the practice of law is a bright line rule. And the rule exists that we will always treat each item the same so that the police have nice, clear rules. They know what to do because there's a lot of these arrests and a lot of these searches every day. So the government's position was, now that we live in an electronic world, nothing has changed. The rules should apply exactly the same. If we can search the cigarette pack in your pocket, we should also be allowed to search the cell phone that's right next to it.
Well, it comes now to the United States Supreme Court in a 9-0 decision. No dissents. The justices all agree and absolutely reject the government's position. Could you tell us a little bit about that?
Yeah, it was a little bit of a shocker. I think those of us who followed the issue closely, you did and I did, I think we're surprised to see the decision be completely unanimous, 9-0, and the court in a fairly sweeping opinion said, we are categorically not going to allow warrantless searches of a cell phone as part of an arrest. For situations like that, the court took the position that the police must go get a warrant.
Now, does that cover everything? Are there any important issues that are still open?
Well, there's going to be a bunch of issues that follow up. Any Supreme Court case always opens certain doors. I think the door that's opened next probably is the door of what's that warrant supposed to look like? And the question there will be, will judges be allowed to just issue a warrant for a cell phone, or are they going to have to particularize that the way most warrants in the United States are particularized to search a particular area or a particular thing? Will the warrant specify, for instance, to search Facebook and text messages and email, but not your photos and not your call history? There's an argument that the warrant should have to be very particularized. At this point, there's really no guidance from the court about how to answer that question yet.
So do you expect a lot of litigation coming over the next couple of years?
I think there will be a lot of litigation about that issue, and there's also going to be a lot of litigation. As you well know, there are other exceptions to the warrant requirement, and I think there'll be a lot of litigation about those as well. And one area will be whether people have actually consented to the search of their phone, and that would be a viable way for the police to get into it, or whether exigent circumstances exist. I don't know if you have feelings about whether either of those are going to be viable claims for defendants to make, or whether they'd be a tough road to go.
Well, I think they're going to be making those claims. And I think they're going to be very serious questions, particularly in a fast-moving case where the police are chasing alleged drug dealers and the like. How it will play out in cases, gosh, it's really almost impossible to know.
Yeah, the Supreme Court is playing catch-up in this area, and they issued a sweeping decision this term But it's hard for them to look ahead because the technology evolves very quickly, and it's just a very difficult area for the court to foresee what's coming in the future.
So you cell phone users out there, keep an eye on the Supreme Court and the other courts in the land. There's going to be some major decisions coming down.